Very sorry about the late start.
No, not at all.
Technical problems again, I'm afraid.
Very good. Thank you very much, my lord. I think I've been mic'd up, amped up, or whatever the right expression is, because I'm talking quite quietly this afternoon. But anyway, so my lords, just before the lunch adjournment, I was seeking to explain the first 2 points in respect to ground one. What I'm essentially saying is that the appellant's case was never one of waiver. He never said in his evidence and never presented his case, oh, I've given up my right to a lawyer, but I didn't do so on an informed basis. His case was always, forget all of that. You know, any question of a lawyer's out the window. I was just dragged down the station, forced to make a confession. So
I don't think he said forget all that. That's quite fair. He said I wanted a lawyer and they didn't let me have one.
Exactly. So his case was denial. His case was denial of a lawyer as part of the abuse. They said, you don't need one, you're just going to confess to all this stuff. Slap. So his case was, in other words, the lack of a lawyer was bound up inextricably with the question of abuse, and that was the case that he was running at trial. That's the first point. The second point flows from that, which is, that being the case, there was no separate evidence on the question of waiver, because it was an issue that didn't arise. The third point is, well, in order for that issue to be determined, someone would have to raise questions about waiver, which leads the appellant to say, well, the judge should have done that. Indeed, ECHR cases are cited to the effect that, well, if a judge doesn't inquire into the circumstances of a waiver, that in itself may be a breach of Article 6. Fine, if the case before the judge is one of waiver. It wasn't. And fourthly and finally, there are really good reasons why, when a case of waiver isn't the case that the judge is looking at, the judge shouldn't create an issue that isn't there and start looking into it, because it can do harm to the case that is being run. Well, can I just develop those submissions, first of all, by looking at the evidence of the officers in the voir dire, in particular Officer Ranger. That's at page 69 of the bundle.
Yes.
It starts at 69, so it's on the 23rd of July 2010, so the appellant's arrested on the 21st. He says he was abused on the 22nd, and then there's this interview on the 23rd. Over the page on 70, so it was Ranger and Smith only. Officer Smith and Officer Ranger are conducting the interview. And then on page 71, the suspect, this is at line 4, the defendant was told that he was a suspect in the armed robbery of a female. He was cautioned, a record of interview was done. I put to him a series of questions to which he responded. Well, not many questions, basically what happened, he told them. Question at line 10. Now, before you put those series of questions, he was advised of his rights to have an attorney, and his response to me, I straight, you all done get me. So the evidence of the officers was he was told of his right to an attorney. And then you get the confession that follows. And then over the page on page 72 at the bottom, 28, is what, if anything, line 28, what, if anything, did you observe about him? On the right side of his face, he had a scratch on his face. When he was asked how he came about the scratch, he'd indicated that prior to him being arrested, he was struck to the face with a rock.
So which page are you reading on?
Page 72 at the bottom,
72.
line 29 onwards. So,
Yeah.
as my Lord Legate said earlier on, obviously there was a further conversation about this stuff, about what happened. I asked him, and there's also evidence from a different officer, Officer Johnson, about taking the appellant out of the station for review in relation to another matter. And then at the top of page 73, he asked him if he wanted to attend the doctor, how his feeling. His response to him was fine. The injury didn't appear serious enough to stop or interrupt the interview.
Where does he say he was asked if he wanted to see a doctor?
At the top on page 73.
Yeah. Extraordinary that the record is full of all these statements. He was fine and no complaint, and now turns out there was actually something looked at and but not thought fit to note in the record.
Yes, I think that's always been the case, that it wasn't thought significant enough to put in the detention record. But that's yes, it was always accepted that he came in the evidence with this injury to his face.
Well, it had to be, because there were injuries that had to be explained somehow.
Well,
And if he didn't come in with them, then there was only one other possibility.
yes, and there was evidence about as I say, from Mr. Johnson about the circumstances by which the facial injury occurred. That was also led into evidence. So, and then again, the evidence of Officer Ranger at the main trial at 166.
So this is Ranger at the voir dire.
In the voir dire, that's right, yes. But just for completeness, it's worth just turning up and seeing what he says in the main evidence as well. He basically says the same thing.
Which is at page?
Page 166,
Thank you.
line 15 onwards. And then again on page 167, line 24, physically was a fine with the exception he had a scratch, minor abrasion to the right side of his face. Line 30, the defendant was told that he was a suspect in the July 16th armed robbery. He was cautioned. He was advised of his right to have an attorney or a family member present. He declined. His response, "I straight, you will get me." As a result, the interview continued. So he's given a standard, and then the interview is read into the evidence on page 170, line 11 onwards. You're not obliged to say anything unless you wish to do so. Whatever you say will be taken down in writing and may be given in evidence. Do you understand what was just explained to you? Yes. Yeah, boss. Are you feeling all right, sir? And this page, which will be the first page of the interview record, was signed. I think it's accepted by the appellant, but he said he was effectively beaten up on the 22nd and then signed all of this out of fear on the 23rd. That was his case. Page 172, line 10. Did anyone force you to participate in this interview or make you any promise? No, sir. So again, that is must be a reference to any inducements or force. And then we can go back to, sorry to jump about, but I just want to go back to the cross-examination at the voir dire, because it's the evidence that was before the judge that's the key on this point. So it's page 75 at the very top, line 1. Why, when I told you all I have nothing to say, why do you all bind and beat me to say what you all told me? No, sir. So how did I receive cuts on my wrist, etc.? So the appellant's case is, I told you I have nothing to say, which is obviously inconsistent with the caution being given and him being told he's got a right to silence. So in other words, the case that the appellant is presenting to the judge and then later the jury is flatly inconsistent with a caution being given. In other words, so when the judge accepts this evidence...
Well, that assumes that the first time he was asked about the offence was when he suddenly just the interview starts and out rolls his confession out of the blue, which defies belief.
Well,
it's simply incredible that somebody's just brought in with no evidence at all. They're told this offence was occurred on its own day, you're accused, and out he comes, oh yes, I committed it.
First thing in the morning.
First thing in the morning. Yeah. First time he's ever been asked about it.
Well, I've already...
I mean, this is...
Well, I've already
this never seems to have been looked at all at the trial, but it's astonishing.
Well, my lord, I've already accepted, I think, that there must have been conversations that preceded this, because...
Well, why weren't they documented? You see, that's all the sort of thing that should have been gone into. And once we go down there, then the whole thing looks utterly flawed.
Well, I appreciate the preliminary observation, but, my lord, I mean, I'm not sure, actually, when it comes...
Well, I find this whole thing quite shocking, actually.
Well, my lord, these statements confirming the caution and confirming what rights the appellant has been told he has to contact a lawyer, a template standard confession, this is a...
Template confession, it looks like.
A template form for the statement that is admitted into evidence. But, my lord, there obviously were conversations that were had beforehand, but ultimately the question before the judge in voir dire is whether his confession statement is admissible. I mean,
do they record interviews now in the Bahamas, or do they still carry on the practice that the interview takes the form of something written out by the police officer, which the accused is then invited to sign?
Well, my lord, this looks a lot like statements that I've seen in other cases.
Including recently?
Well...
Although, I mean, obviously, this is a long time ago now. I'm just wondering whether the practice might have improved.
I tend to deal, frankly, with cases that are years old, to be honest.
Yeah.
But certainly the tab 4 of the Authorities Bundle, Volume 1, sets out some relevant material on interviews. So this is at page 623, my lord, in answer to your question.
The standing orders.
I've got 623. Hopefully, 623 says at paragraph 59, interviews with detained persons. I'm hoping.
Yeah.
They still have this practice of conducting inquiries, which I've seen Mr. Johnson's evidence is about basically the police taking somebody out, and in those circumstances what they say might be taken down in a pocketbook rather than in a statement. But it says at paragraph 60, where possible a record of interview will be recorded contemporaneously on the special forms provided, right, which is what I mean by template. Alternatively, a record which adequately and accurately summarises the interview must be made in the officer's pocketbook as soon as practicable thereafter, and it'll explain, the pocketbook should explain why the contemporary record was not completed. So that's how it's meant to, well, that's at least what the relevant rules say about it. In terms of the detention record, I'm not sure that the detention record, I suppose it does list out interviews, but for example on page 13 of the bundle, I mean, there a record on the 22nd of the 7th of officers taking the suspect out with the suspect. So anything said during that journey wouldn't be in the form of a statement. And there is also an entry at the bottom on the same page. And I don't know what that refers to. It says Roach interviewed, and I don't see where the rest of that is. It may be that my friend can help, but I don't think the detention record is, in that respect, necessarily conclusive of all interviews or all statements that took place. But it's true that at the trial, the only statement that was in evidence was the final confession statement. But obviously, conversations were had beforehand. I mean, that's obvious. But the point is, it's the confession statement that's the evidence against the appellant, and it's that evidence that's being challenged, and the basis upon which it's being challenged is abuse, and he has his medical evidence, and the officers are called. But at this point, in any event, I mean, that's really drifting in any event to sort of ground 3, which is a frontal challenge to the judge's admission of the evidence. And there are concurrent findings of fact on that. In fact, if you include the jury, triple findings of fact that the statement was given voluntarily. But the point at the moment in ground 1 is whether there is really any viable basis for saying that the judge should have inquired, off his own bat presumably, into some entirely separate case about waiver. And I say no. Because that just wasn't the appellant's case. Finally, just turning up the evidence of Officer Smith. That's at it's page 62, again in the voir dire. '62, please. Yep. And he confirms that on the 23rd of July he sat in on the interview with Mr. Ariste. And page 64, line 6, did your officer arrange to threaten him before the interview began? So that's, of course, when the caution was allegedly given. So again, the jury really is left in a binary. The judge, first of all, and the jury later are left in a position of binary acceptance or rejection of the police's evidence, because it's all bound up. The point about caution and whether you were asked if you wanted to see a lawyer is all bound up with the abuse. And then again, he confirms that during the interview, DC Ranger cautioned Mr. Ariste. He asked him if he wished to have a lawyer or a family member present. However, he declined. He stated, "No, I straight, you all got me." So again, it's the same point. Mr. Ariste said that in response to the question of whether he wanted to have a lawyer. So it's all bound up together. Then there's the evidence of the appellant himself. My lords, that starts at 211, or the bit I want to turn to does in any event. That's at page 211. So, my lords, that's at lines 19 onwards. The next morning, so he was arrested on the 21st, the next morning, 22nd, they came for me, carry me to CDU, ask about his brother, and then they start beating me, punching me in the face, and so on. They questioned me at the bottom, line 32. I told him I have no knowledge of these crimes. Then after that, they came through a baseball bat and a cutlass, start hitting me on my hips, start beating me all over my body with a baseball bat. Pausing there, no medical evidence of any of that. Then the officer tell them, get the fish bag.
Well, apart from bruises on his buttocks.
Well, hitting me and start beating me all over my body with a baseball bat. That's the point. He's saying he was beaten all over his body with a baseball bat. There's no evidence of that at all. What there is evidence of is a temporal abrasion. The evidence is that was caused by a rock. And he was also said to be involved in a car crash. So, cutlass is, I think, a knife. They start beating me again with a baseball bat and cutlass. Line 19, after that, they start interviewing me or questioning me and telling me. So while I was in fear for my life, they start telling me how this scene happened. They start coaching me by telling me, all right, this is how this person get robbed, and so on. And then they was just forcing me to sign, which I signed. And then at 216, just for later purposes, at line 20 onwards, the appellant confirms that he wasn't beaten up on the 21st. He wasn't beaten up at the time of the arrest. And he's asked if his memory on that is good. He said, I remember the night because I remember the look on my mother's face. That becomes relevant in terms of credibility of the fresh evidence that's now before the board, which is totally inconsistent with that. And then at 217, further details about the alleged abuse. And then, my lords, I'd ask you just to turn to 228, please. Line 22. I wouldn't say I tough, but I easy. If you put a gun to my face, that would put enough fear in me. It didn't put enough fear in you to cause you to want to give a confession. They put enough fear in me to scare me out to sign what they told me. And then at 230, page 230, it's confirmed that he signs each page, including what necessarily the caution page. So his evidence to the judge, and the judge must have understood this, his whole case was none of this confession statement, including the caution and including the fact I was read my rights and all the rest of it, is true. And in my respectful submission, it was for the judge to either accept or reject that in whole. And the same for the jury.
It was also for the judge to give some reasons if he was going to reject it. Well,
my lord, I'm very happy to address those points, but that is a different ground. It may be that I need to address those points, but that is a different ground of appeal, and the entire this morning was spent on this ground.
Maybe relevant to the concurrent findings point.
Mm. Well, I accept, but I can only respond to the way the case is put, but I appreciate the fact that I do need to address ground 3, and I will address ground 3, but what I'm saying for the present purposes is there just wasn't a separate case of waiver.
Yeah.
The confession statement, if it remains in the evidence, shows that the appellant was not denied a lawyer, which is the actual case against me, was put against me. Because if it's true, beyond reasonable doubt, that a caution was given, he was told he had a right to have a lawyer and declined, then that case can't succeed. That allegation against the respondent can't succeed. And the alternative allegation, well, you can't be sure now that the appellant gave full and informed waiver of his right. I say that's just nonsensical. It just was never the issue before the judge. Some issues arise in some cases and some issues don't arise in other cases. There's no good citing all of this detailed ECHR case law on waiver in circumstances where it just doesn't apply on the facts. And the case against me, finally, as well, all right, even if the appellant wasn't saying waiver, the judge should have considered the question of waiver. But the problem is there's no evidence about the circumstances in which, other than the confession statement, which just considers, you were given a caution, you declined a lawyer. Other than that, there's no evidence as to the circumstances in which he came to decline a lawyer. So, for example, we don't know whether he gave any reasons. We don't know whether there was an inquiry into the reasons. We don't know whether he said it's because I can't afford one. We don't know whether there was an attempt to contact a lawyer who refused to assist. We just don't have any of that information. So, but the only way in which the appellant can expect the judge to, first of all, himself have considered the issue of waiver, and secondly of all, expected the jury to consider it at the main trial, is for somebody to elicit that evidence. So somebody, and it's not going to be the appellant, because he's just not asking those questions, so somebody, ergo the judge, needs, apparently, to start himself inquiring into this question. And my lords, I simply say that is a recipe for disaster, because, and one can test this by looking at each stage of how the trial actually works. So the first stage at which the judge could ask those questions would be during the voir dire. So when the judge is considering himself whether he accepts the story of abuse or whether he says to the criminal standard the statement was voluntary, the proposition must be that the judge himself would start saying to the officers or the appellant, either which is a disaster, by the way, what inquiries, if any, were made into getting a lawyer for this guy? Now, what the appellant may turn around and say is, well, I don't know what you're talking about, Judge, first of all, because my case is that they beat me up. This doesn't come into it. I don't know why you're asking these questions. That's the best case for the appellant. The worst case is the appellant starts leaking evidence that is damaging to his case on abuse. Because he says, oh, well, it's funny you should say that, because, I did make a phone call to my parents to see if they could come.
Well, this is an alternative reality you're constructing.
No, I'm going through.
I appreciate your point that he didn't ask any, the judge was sensible not to ask any questions.
Very sensible.
To start postulating that sort of answer is plausible, it takes it into the ridiculous.
Well, with the greatest respect, I don't agree, my lord, because you have to test the case, and the case put against me is that the judge should have inquired into these issues, and I'm saying there's only two sorts of evidence that would come out. Either the appellant would say, well, that's just not my case, forget it.
We know what his case was because he said it.
Yes, but there's a very real and significant danger that he would give evidence that harms his case on abuse, and he's asking the judge to find, beyond reasonable doubt, that the police abused him. So if anybody would put the question to the police, there's nothing fantastical about it. If you ask the police during the voir dire, well, what steps did you take? And they start saying, oh, well, we allowed him to phone his mum, or anything. Of course, that ruins the abuse argument, because why would the police officers be doing that if they were busy beating him up? So it's a very real point. There's nothing fantastical about these submissions. There's a very real reason why a trial judge would just never do that in a case like this. Well, Lord, to just turn up at this stage the case of Akdag, which is one of the cases put against me on this point. It's in the Authorities Bundle 1, tab 17. I should just say, by the way, my lord, I don't want to test my lordship's patience on this point, but the very same problems, of course, arise if the judge decides the voir dire and then seeks to raise the same questions of evidence during the trial.
What page are we going to, please?
Right, so it's page 901 in the Authorities Bundle, 901.
Yes.
And I don't accept that these cases necessarily fall to be followed in the Bahamas, but nonetheless it's worth just appreciating the factual made, because your lordships were taken to it by the appellant, so I'll seek to explain what actually happened. Paragraph 9, this is on 904. Paragraph 9, the applicant was taken to the
Paragraph 9, 904.
Yes, so it's 904
Yes.
of the bundle, paragraph 9. On 14 November, she was questioned by police officers in the absence of a lawyer. The applicant's statements to the police were transcribed onto printed forms, etc. A few lines down, it appears from the form that the applicant refused legal assistance, since the first page of the record includes a printed phrase stating no lawyer. She gave a statement of 9 pages and then admitting membership of yet another PKK case. Paragraph 11, a few days later, or 3 days later, on the 17th of November, she said to a doctor that the police had hit her head, threatened to kill and rape her, and driven their car into her, as a result of which she'd lost consciousness. She then denied the statements in front of the public prosecutor. Paragraph 12. And then over the page onto 906 of the bundle, paragraph 22, the Istanbul Assize Court found, on the basis of those statements, that she was a member of the prohibited organisation. And then paragraph 23 is critical. According to the reasoned judgment, 7 out of 15 of the accused who were tried alongside this applicant denied those statements either before the public prosecutor or before the investigating judge. Just pausing here, we're talking about, by the way, an inquisitorial system, not an adversarial system, which is also a relevant consideration, of course. Moreover, 14 of the accused had denied the accusations against them during the trial. However, the reasoned judgment did not contain any examination of the admissibility of those statements. So I think what's being said here is the assize court never actually looked into the question of abuse. It's just never a tried fact. So then we come on to page 910, paragraph 46. Nothing prevents waiver. However, must be established in an unequivocal manner and attended by minimum safeguards. Such a waiver need not be explicit. You don't even need to expressly say it, but it must be voluntary and constitute a knowing and intelligent relinquishment of a right, etc. And then paragraph 50 on 911, turning to the particular circumstances of the case, the court observes that according to the statement form dated 14 November 2003, which the applicant signed, she was informed of her rights, including her right to have legal assistance and to remain silent. She said she did not want a lawyer or to remain silent. Well, that's what happened here. Moreover, the court notes that it was an essential that the applicant be clearly informed about the consequences of not requesting an assistance of the lawyer. Primary among those consequences, of course, is the fact that if you don't ask for a lawyer and you end up giving a statement, the statement will be used against you in evidence in court. But of course, pausing there, the common law caution that was applied in this case, of course, does include that warning. And then over the page on 913 at the top, we're halfway through a paragraph, so it's page 913 at the top, access to a lawyer both before the public prosecutor and the investigating court, blah, blah, blah. Furthermore, as will be examined below, the trial court does not appear to have subjected the applicant's police statements to scrutiny when using those statements to convict her. And then an analogy is drawn between that case and the case of Roussan Bayer, which also cited by my learned friend, which is of the same order. The court held again that the government were not able to show the validity of the applicant's waiver to a lawyer on the basis of the documents he'd signed, given that the applicant had contested the contents of his police statements. So the problem in both in this case and in Bayer is that there's an unresolved question of whether there was abuse. And in those circumstances, obviously, it's very difficult to accept a case on waiver unless you actually resolve the question of abuse. But of course, in this case, subject to ground 3, the question of abuse is resolved. And abuse is found not to have taken place by the judge, by the jury, and by the Court of Appeal, which of course puts a completely different light on these cases and how they actually apply on the facts. And it's in that context that the court concludes at paragraph 70 on page 916 that the absence of a close scrutiny by the national courts of the circumstances surrounding the applicant's waiver and the fact that this was not remedied by any procedural safeguards rendered the trial as a whole unfair. But of course, those are circumstances where someone saying was beaten up to make these statements, and the court says, well, that's very interesting, I'm not going to investigate it. Well, that's hardly this case. So I do say respectfully, my lord, if the confession statement stays in, and it may or may not, but if it does stay in, there is no separate question of waiver, and ground 1 falls to be dismissed. My lords, before I leave ground 1, I do just want to say a few things about the burden and standard of proof. And it does depend on the issue that's raised. But it's an issue that has ramifications in other cases if my learned friend's submissions are accepted. And what I say in summary is this. Point one, if the issue of legal representation is raised at first instance, or it arises on the evidence, then probably the burden would be on the Crown to the criminal standard to establish what happened. But the reason for that is because it's a question that may, depending on the facts, go to voluntariness. However, in this case, point two, that issue did not arise on the evidence, and for the reasons I've said, could not have been created by the judge. So then the question comes, and this is point three, where the question is raised after the event in support not of a challenge to voluntariness, which is ground three, but in support of a claim that the trial was unfair, two fundamentally different things. There, the civil standard applies as it would to any claim for a breach of constitutional rights or an appeal based on a breach of constitutional rights, whether or not that claim or that appeal concerns criminal proceedings.
You say the burden falls?
The burden of proof is a slightly more slippery.
Oh, I'm sorry, I didn't quite...
Well, what I say is that
The challenge is not to the voluntariness, but to the claim that the trial was unfair.
Yes, so when a litigant avers that that their trial was unfair, either in separate constitutional motion proceedings or as an appeal, I say that the civil standard applies. The burden of satisfying the court that there has been an unfair trial rests on the claimant or the appellant in the usual way, but sub-questions of fact, for example, questions of waiver, I would accept. The court will adopt a flexible view because, of course, other things being equal, a prosecuting authority will know the circumstances of the waiver better than the individual. But it's not right, and this is an important point, it's not right, in my respectful submission, for the appellant to say, on an appeal, when they're not raising lack of legal representation as a question of voluntariness, but they're saying, my trial was unfair for the first time on appeal, it's not right to say that the burden of proof is on me to prove to the criminal standard all the facts and circumstances by which they came to be without legal representation at the police station, and for ground two, during the trial, and for me to prove somehow to the criminal standard that their trial was fair. That's just not how it works in my submission. And the reason why it doesn't work like this, let me just skip forward, sorry, just bear with me. So those are my submissions on question of legal representation in the police station. And the reasoning is, again, another sort of 5 or 6 propositions. But the first one is an obvious one, which is that the prosecution must prove the offence to the criminal standard. So obviously no argument about that. Proposition 2 is, in practice, that means the prosecution must prove the actus reus and the mens rea to the criminal standard. Point 3, I'm hoping points 1 and 2 aren't controversial, but point 3 is, if any defences are raised, the prosecution must disprove any facts comprised in those potential defences, for example, self-defence or provocation. And the reason for that is because a defence goes to the question of whether the actus reus or the mens rea are met, generally. So they're lumped in. So disproving a defence is lumped in with the prosecution's duty to prove the actus reus and the mens rea. So in other words, they have to disprove the defences because that's really part and parcel of their ongoing duty to prove the offence. So that's why defences are lumped in. Again, I don't think that's controversial. Point 4, the prosecution, if it seeks to rely on a confession, must prove that it was given voluntarily. And again, it's the same idea, because of course a confession that isn't given voluntarily isn't a confession at all. It's just something somebody says while they're being beaten up. So because if the confession is admitted into, I'm sorry this is all a bit obvious, but this is how I've reasoned through it, but if the confession is admitted into evidence, it proves the actus reus and the mens rea, and therefore it follows that the prosecution must prove beyond reasonable doubt that it's given voluntarily. The reason why I make those 4 hopefully sound and uncontroversial statements is because one can then see why questions of constitutional breach don't necessarily fall into that category. And why I say Lord Steyne either didn't mean what he said in Mohammed or just got it wrong. We'll come to that case in a moment. One example, this is point 5, is collateral issues. This is Phipson on evidence, so it's not in the bundle, but Phipson on evidence refers to collateral issues. For example, in a criminal trial, in certain circumstances, a defendant can treat their own witness as a hostile witness. But there's no consideration in the authorities of what standard the judge needs to be satisfied to in order to treat somebody as a hostile witness. And there are tons of those collateral issues, and there's quite an interesting section in Phipson on that, largely unexplored issue. But then we come to human rights or constitutional arguments. First of all, at first instance, let us suppose a claimant says, let us suppose a defendant says, as they sometimes do in the Caribbean cases, you can't rely on that phone tapping evidence, or you can't rely on a recording of my voice taken from some source, because it will breach my constitutional right to privacy. That will often be referred off and decided in constitutional proceedings, but the usual civil standard would apply, in my respectful submission. There's no suggestion that just because it's a criminal case, everyone starts applying a totally different reverse criminal standard. And it's the same with fair trial issues, I say. So I've given 2 cases, given 2 examples in my case. I'm only going to take your Lordship's time up by looking at one of them, which is Hewitt. That's in, well, your Lordship, it doesn't matter what bundle it's in, does it? You just want the number, which is 1787. But it's at tab 48 for everybody working from paper. In tab 48 in volume 3A. And this looks like to be a judicial review or a case stated before the admin court. 1787. Claimant seeks an order quashing her conviction on the basis that there was a real possibility the district judge was biased, and the claimant therefore did not have a fair trial under Article 6. The alleged victim, this is paragraph 4, of each offence was a man called Robert Smith, who was employed as a terrier man by Flint and Denby Hunt. And the basic suggestion was, you can pick it up at paragraph 8, is that the judge may have had some connection with hunting, shooting and field sports generally, and therefore shouldn't really be sitting on a case about concerning an alleged assault by somebody against a huntsman, basically. That's basically the point. Paragraph 11. During the hearing before me, I considered it at least possible that there might be a dispute of fact about what occurred at the sentencing hearing, which took place on 11th of December. And then over the page on 1792, at the top, it became apparent at the hearing before me that the claimant and her representatives had not seen the affidavit of Miss La Grua, therefore indicated would permit further evidence. So she's seeking and receiving witness statements from people. And then at paragraph 15, it's common ground that in order to ascertain whether a fair-minded and informed observer would conclude there's a real possibility of bias, necessary to identify all the relevant factual circumstances. And then the judge goes on to make a whole series of findings of facts, and there's no suggestion. I mean, it's not authority for anything other than just an example of how an Article 6 fair trial challenge works. And she goes on to find all of the facts there without any hint or suggestion that there's somehow some reverse criminal burden on the prosecution to prove or disprove all of the facts relied upon in support of the unfair trial claim. I think that's absolutely, with respect, right. And I've cited one or two other cases in my case that make the same point. And at paragraph 21, on the whole of the evidence adduced before me, I'm satisfied that the district judge did not recuse himself from passing sentence because he acceded to a submission, etc. So the judge is happily there making findings of fact, deciding an Article 6 claim. It's not an appeal, but that's by the by, without any hint or suggestion that somehow it's for the prosecution to prove all of the facts underlying the other side's claim. Now, as I say, the position might be different if it's raised for a different purpose at the trial, if the issue of facts is raised at the trial for a different purpose. By my reckoning, I don't have a huge amount of time left, so can I just give your lordship some references? Simeon Novi,
we were late starting.
Sorry?
We were late starting. I think you have until 3:30.
3:30, okay.
And we were late starting.
Well, I don't like to take too long anyway, but so let me just...
I'm not encouraging you
no, quite.
to address this at any greater length than
nobody ever encourages me to speak for longer, that's for sure.
You shouldn't feel under any constraint of time at the moment.
I'm very grateful, thank you very much. I've just got two more grounds to do. So, Simeon OV. Perhaps we can very quickly just turn that one up. It's at 1126. 1126. Where am I? 21. I think I can zip through to paragraph 92. Just where the court sets out, this is 1165 of the bundle, 1165 onto 1166, where Article 6, the relevant part of Article 6, is set out.
Paragraph? Yes.
Everyone charged with a criminal offence has the following...
Paragraph 92, is it?
92, onto the next page.
Yes.
So that's the first point to bear in mind, just to the text of Article 6. And I'm dealing here at the moment, I should say, just to flag up 2 points. First of all, the standard of proof under the ECHR, and secondly of all, whether actually these cases are helpful when your lordship come to deciding a case under the Bahamian Constitution. So 2 points. The first is the text. He has a minimum right to defend himself in person or through legal assistance of his own choosing, or, if he has not sufficient means to pay for legal assistance, to be given it free when the interests of justice so require. So there's basically a requirement for legal aid. And then paragraph 110, the protections afforded by Articles 6, 1 and 3 apply to a person subject to a criminal charge within the autonomous convention meaning of that term. A criminal charge exists from the moment that an individual is officially notified of an allegation that he's committed a criminal offence. So in other words, certainly by the time that you're being interviewed under caution, and it's put to you that you've committed an offence, these requirements are engaged. And then paragraph 112, the court reiterates that the right of everyone charged with a criminal offence to be effectively defended by a lawyer, assigned officially if need be, is one of the fundamental features of a fair trial. Prompt access to a lawyer constitutes an important counterweight, etc. And then paragraph 116, which is on page 1172, court also reiterates that access to a lawyer during the investigation phase may be temporarily restricted where there are compelling reasons. It's a separate question as to whether or not there's been waiver. The court, and then there's an extract from Saldus. The court finds that in order for the right to a fair trial to remain sufficiently practical and effective, Article 6.1 requires that, as a rule, access to a lawyer should be provided as from the first interrogation of a suspect by the police, unless there are compelling reasons to restrict this right. So the position, as far as I can tell, under the ECHR is, as soon as you're in a position where you're in a police station and somebody's putting allegations to you, the state's got to provide a lawyer. What I want to just do is just pausing there and taking the point about the position in the Bahamas and the textual differences. It's worth just turning up Article 19 of the Constitution, which is at page 586. Yeah, 586, so this is 19.2. Any person who is arrested or detained shall be informed as soon as is reasonably practical in language, etc., the reasons for his arrest, etc., and shall be permitted, not provided, but permitted, and that's the word that their lordships focus on in the Hines case from the Bahamas, at his own expense to retain and instruct without delay a legal representative of his choice. So it's at his own expense. And Article 19 is a protection from arbitrary arrest or detention. So unlike Article 6, where everything's lumped together, in the Bahamian Constitution, what happens before court is separated out from what happens during court. And the position is crystal clear. Before court, it's at your own expense. That's what the Constitution says.
What do you say the position would be if, in relation to confession, it was shown, well, if the position was that the defendant had, if the prosecution did not establish that the lack of presence of a lawyer was a voluntary choice? In other words, they didn't show either that he'd been given the choice or that he freely exercised it. Would the confession be inadmissible, or would it still be admissible?
I think the question is... Sorry, just run it past.
So, sorry, I didn't put it very well, it's my fault. Suppose that there's an issue as to whether the defendant had voluntarily chosen not to have a lawyer present. And the prosecution failed to show that he'd made a voluntary choice, either because they didn't explain to him that he had the right, or because, for whatever reason. What effect do you say, that, if any, that would have on the admissibility of the confession? Would it render it inadmissible, or would that be a discretionary matter for the judge, or what would the situation be?
On the present state of the law, in the Mohammed case, it's a matter of discretion, not freewheeling discretion. You have to look very seriously and closely at the impact on the fairness of trial.
So it's the Mohammed case is the authority?
Yes.
Go. Thank you.
And then at 587, these are provisions to secure the protection of the law.
Sorry, where are you now?
This is Article 20 of the Constitution. It's on page 587.
Yes, thank you.
It talks at 20 subsection 1 about a fair hearing by an independent and impartial court. So we're now talking about trials or hearings in court. And it's there at 22D. The defendant shall be permitted to defend himself before the court in person or at his own expense by a legal representative, or by a legal representative at the public expense, where so provided by or under a law in force in the Bahamas. It doesn't create a right to legal aid, but what it says is, if the legislator has provided legal aid, by which I mean, broadly speaking, financially, free appointed counsel or money to go and spend on one, whatever it is. If the Parliament has done that, then you can avail yourself of that. But there must, in my respect, submission, be a very real and deliberate choice about the difference in language between these two provisions. It's not like Article 6, where it's all just dumped in under one article and left to the court to decide for itself what the requirements are. And that is why, in the Bahamas, you have a bifurcated system. So when you have a court process, you can say to the judge at an early case management hearing, the judge will say, well, do you have counsel? No. Okay. Can you afford one? No. Right. Okay. Well, let's see if you meet the Crown brief criteria. And if you do, you get counsel appointed for you. And the same in the Court of Appeal. But what you don't get is something in between, or before you get to court. So there are two areas where there isn't at the moment legal aid in the Bahamas. One is pre-court process, and the other that I think some of my lordships sat on the Pierre Rodriguez case, which is all about extensions of time to appeal. And there's another gap there, because until you've actually instigated your appeal, you don't get a Crown brief. So there's no legal aid to help you, for example, formulating your grounds and applying in time and all that kind of stuff. Now, for the reasons I said at the beginning of my submissions, I'm not in a position to give chapter and verse on these provisions and how they've been interpreted, because they're only presented with the case about legal aid 5 minutes before court. But in my respect for submission, the first place I would start is just looking at the text and saying, well, it just doesn't. It's just fundamentally different from the European Court of Human Rights, European Convention of Human Rights provisions. And that's the... I don't think I can take that point any further at the moment, given the time constraints, other than just to say that there is a significant difference there that's not been explored in the authorities by the respondent, because they've not been able to get that material together in the time available since the supplemental case was served. But I'm now going to return to the related point, which is the one I intimated earlier, that the European Court of Human Rights case law that sets out these very prescriptive requirements of what must be done in order to establish a waiver, is based on the fact that there's legal aid. And all I can say is it's very clear, if your lordships read Simeon Ovey and the other cases that have been cited, that that's how it fits together as a package. The police are able to say to somebody in detention, well, are you sure you don't want a lawyer? because one will be provided free. It's a bit odd that you don't want a lawyer. Don't you think it would be a good idea? Or is that option just not available in the Bahamas? Because the answer will be the police just don't have the power to appoint one. Finally, on the burden and standard of proof point, my lords, back to Simeonova, I'm afraid, which is at 1174. Paragraph 124, the court reiterates that in order to assess this evidence, it adopts the standard of proof beyond reasonable doubt.
Sorry, paragraph 124. 4, thank you.
So this is even assuming that the ECHR case law does apply, and assuming there's a reverse burden on me, which I don't accept. But even if that's right, it's then said against me, well, what the European Court of Human Rights does is requires the state to prove waiver beyond reasonable doubt, and that's the criminal standard. And what I just say, in short, is that is not the criminal standard. When the ECHR talks about beyond reasonable doubt, it does not mean the common law criminal standard, because reasonable is applied in a flexible way. And we know that because it's the same standard that applies when an applicant brings a complaint before the European Court of Human Rights. And a complaint before the European Court of Human Rights could hardly succeed in the vast majority of cases if there was a criminal standard imposed against an applicant. But that is indeed the standard, and I'll just invite the Lordships to follow up footnote 49 and the Ireland case where all of that is explained. And then lastly, at 11, page 1184, sorry.
Whose judgment is this?
Sorry, forget that. Sorry, I'm now in a different case. I just want to give your Lordships one reference, which is 2345. 2345. I hope that's right. 67. Two, 3, 4, 5 is a different case, but it just explains there at paragraph 48 that the beyond reasonable doubt test has never been the court's purpose to borrow the approach of the national legal systems that use that standard in criminal cases, etc. It explains, basically, it's not the criminal standard at all. And when one looks at how the allegation, how the question of waiver, the factual question of waiver was resolved in Simeonova, it's obvious that the court is not applying a criminal standard. And with respect, the appellant's just wrong about that. It's not the standard the ECHR actually applies. Right. Ground 2. Because it's an allegation that the trial was unfair because the appellant was left without legal representation, because that is a fresh point taken on appeal, in my respectful submission, the normal civil standard applies. It's for the appellant to prove their case. It is not for the respondent to disprove, to beyond reasonable doubt or to prove beyond reasonable doubt the facts underlying that claim. It is for the appellant to persuade your Lordship's board, first of all, to accept this due point at all in circumstances where it wasn't taken in the Court of Appeal. And if your Lordships are prepared to listen to the complaint, it's for the appellant to establish why and the circumstances surrounding the fact he was left without his counsel. He's not done that, in my respectful submission, for the reasons I've already set out in the case. I accept that the main factors that have been referred to earlier on, i.e. the desiderata or the considerations that the board says a judge should consider, should have regard to before allowing a counsel to demit, I can't say whether those, I'm not going to waste your Lordship's time, I can't say whether the judge had regard to those matters or not, because there's no transcript of the hearing. So, I mean, I just can't say. But I deal with it in two ways. First of all, burden and standard of proof. It's for the appellant to prove what happened. If the appellant had taken this point in the Court of Appeal in 2013, that was just a year after the trial, and he was represented by counsel at that stage, all of these matters could have been investigated. They weren't, the point wasn't taken, and that's not, with respect, my fault. There's no particular reason why the court should bend over backwards to apply a more flexible standard when the point is raised some 10 years later. Then I rely on a point, I'm just going to give your Lordships the reference, a point in Hines. That was a constitutional claim, not an appeal. It was a constitutional claim that the appellant's separate trial was unfair because he didn't have legal representation. And what the board said at paragraph 19 of the judgment, 1919, I think that's at 867, or thereabouts. What the board said is, well, when you look at the question of fair trial, you have to look not only at the trial, but the appeal. So when you had a trial without legal representation, you then had an appeal and an opportunity to raise all of these points on appeal. And you didn't. And the court's not now going to go back and start unpicking the reasons that may or may not have existed for you to not run those points. It's sufficient to say it was open to you to run those points and you didn't. Therefore, you can't say that you didn't have a fair trial. Now, that was a constitutional motion, not an appeal, but I say that doesn't make any difference when the ground that's being run on the appeal is a breach of the Constitution. You cannot make a sensible distinction between that. So the same reasoning must apply here. You can't say you've had an unfair trial in circumstances where you had counsel in the Court of Appeal and you didn't run the point, and you haven't come to the board to explain why the point wasn't run. You just say, well, it wasn't. It's now 10 years later. We'd like to run it now. My respectful submission, that point's already been decided by the board in Hines. It doesn't wash. The second related point is a decision from England and Wales called Jones. That's at 887 in the authorities. That is a case where the appellant sought to adduce fresh evidence on appeal to overturn his conviction for murder, and the evidence was a psychiatric report which concluded facts that would have met the definition of diminished responsibility. But unfortunately, the defendant himself died before the appeal, and the prosecution said to the Court of Appeal, well, actually, the problem is the expert's report is based largely on matters that the appellant was reporting to the psychiatrist. So in other words, he's relaying events, and those factual events are relied upon in support of the expert report. And the prosecution doesn't accept those facts. But it's impossible, obviously, to cross-examine the defendant because he's died. So they said to the Court of Appeal, well, we win the criminal case. To which the Court of Appeal said, no, you don't. This is an appeal. You need to satisfy us. A, to hear the appeal on this new point, and B, that the fresh evidence is sufficiently reliable to give rise to doubts of the safety of your conviction. And without cross-examination of the defendant, you don't meet the test. End of the story. Now here, of course, it would be possible, at least in theory, for your lordships to have Mr. Ariste come and give evidence and be cross-examined. But assuming that's not happening, and assuming there's no application for that to happen in the Court of Appeal or anywhere else, we're in the same boat. And I say it doesn't follow. It doesn't follow that the appellant wins. What it follows is that 10 years after the event, they can't prove their case.
What gives me some feeling of concern is that taking, I think Mr. Archer, is it, who's provided an affidavit, taking that as the best evidence of what happened. He had the counsel who was he'd been languishing in custody for 20 months, waiting for his case to come on. He then comes thinking he's going to have a trial. His counsel tells him, no, I'm sorry, I've got something else, I'm going to have it adjourned. That puts, if he wants to have his case dealt with and believes he's innocent, that puts tremendous pressure on someone to go ahead unrepresented. And certainly, if you were the judge, you'd want to make really sure that he understood the consequences of that. You'd want to try and arrange alternative representation if it was possible. You'd want to let him know when his case would come back if he had to wait for it. Now, I appreciate we don't have any evidence that those things weren't done, but it at very least leaves a real feeling of concern about what took place.
Well, yes. I don't think it's for me to disabuse your lordship of that feeling. I don't expect.
No, I mean, at the end of the day, if we think the conviction is unsafe, then we don't let it stand, do we?
Well, it has to be.
It's only one of various factors on its own.
Yeah, well, I
can see it won't be alone, but
yes. And I'm not here to win at all costs. I'm here to present the arguments and the cases, and to work through the process in the usual adversarial way. And if your lordships end up in a situation where there's a lurking doubt for a whole plethora of different reasons, none of which individually would get the appellant home, but still left with a sinking feeling in his stomach that something went wrong, then there's not much. That's the test. But in my respectful submission, it is difficult because, of course, it's of great concern that somebody was represented in the Court of Appeal. The starting position must be that their counsel looked at the papers, thought about the point, and received instructions. And I mean, there's no.
Well, then it gets harder and harder. If you start off with no representation, and in the Court of Appeal, it's dealt with in about 2 minutes, and points are not taken that plainly should have been taken, it ends up being. Then it gets relied on that, well, that means you've had it. It's a slippery slope that you carry on sliding down.
Well, my lord, it's not quite straightforward, that, because, of course, it's entirely open to an appellant to say, which I invited the appellant in this case to do. It's not a criticism, by the way, of the excellent work that Simmons, Muirhead and Burton do, but the fact of the matter is, there doesn't seem to me any particular reason why the Court of Appeal counsel couldn't have been asked, why didn't you take the point? Because, of course, the answer might be, well, I spoke to my client and he told me that he wanted to press ahead and, the judge said to him. Because, I mean, look, the appellant's evidence on this is, I asked the judge if I could have counsel and the judge said no. No, you're not allowed, you're not going to have a Crown brief, we're going to get on with the trial. I mean, that's his evidence. With great respect, it's just very unlikely. but the alternative case that your lordship's postulating to me, we just don't know. But in circumstances where somebody is represented in the Court of Appeal, the starting position, in my respectful submission, has to be, well, they will.
No, but I mean, we know he wanted to be represented initially at the trial, and then he decided to go ahead without it. Now, yes. It's not the sort of person who just says, I don't want counsel, I'm determined to do my own case. So that's what gives rise to cause for concern. It looks as though he was he hadn't initially chosen to do the case on his own, but that's how it ended up.
Yes. Well, in respect of the confession statement, which is ground 3, I simply say, actually, the judge applied the correct standard. He considered the evidence.
How do we know? What standard the judge applied and what consideration he gave? He didn't tell us.
Well, because it's...
He didn't explain whether he didn't deal with the obvious points that it would need some explanation as to why he found it proved beyond reasonable doubt despite X, Y, Z.
Well, in my
A
respect,
lot of others.
yes.
If we'd seen that, but simply left us with nothing.
Well, in my
And that in itself is surely a failure of process.
Well, in my respectful submission, obviously reasons should ideally be provided, but
It's not a matter of ideally.
well, there's quite often not very extensive reasons.
Very extensive is a different point.
If reasons are given at all. But my lord, in this case, respectfully, the Court of Appeal did look at the matter again, and
Did they? What consideration did they give to whether the judge had given reasons? They don't seem to have even considered that point.
They looked at the matter again. I'm talking about the question of the admissibility of this statement. That's what they looked at again. So you have a situation where the trial judge looks at it. In my respectful submission, it's obvious why the trial judge... I don't have time to go through all the references, but if your lordship reads the cross-examination of Dr. Hastings during the voir dire and the cross-examination of Dr. Hastings at the trial, the main difficulty in the voir dire is that Mr. Hastings' evidence was these injuries were 2 to 3 weeks old. That's the medical evidence. You can say to police officers until you're blue in the face, you hit me, you hit me, you hit me. They're always going to say the same thing, aren't they? No, of course I didn't. Don't be silly. That's not going to take you anywhere. So the refuge for the judge, obviously, as with any judge, is to say, well, look, are there independent documents? Not really. Well, what does the expert say? Well, the expert says these are old injuries, which is consistent with something happening before he was arrested. So you don't need a reason.
But he gave an opinion as to the likely length of the injuries, but you have to consider that alongside all the other evidence, such as no evidence that as to his condition when he came into custody.
Well, that's it. There isn't any other evidence. I mean, all there was...
Exactly.
Well, exactly. There's nothing to doubt the expert. The expert says these are old injuries. That's the reason, no doubt, that the judge said, well, look, I just don't accept that these were injuries inflicted in prison. The Court of Appeal then looks at the evidence again and comes to the same conclusion. And, of course, the reason why the jury, no doubt, rejected the abuse argument was because, of course, the expert's inconsistent statement about 2 to 3 weeks was put to him in cross. Well, earlier on you said 2 to 3 weeks, now you change your evidence, basically. Well, of course, that's a hopeless basis. There's no surprise at all why the allegations of abuse were rejected. You don't need detailed, you don't need any reasons, frankly, but if you do need them, the Court of Appeal gave them.
Right.
And the difference, finally, just between the conclusion in this case and the conclusion in the 2016 trial, in my respectful submission, has nothing to do with the appellant or the appellant's representation. It has everything to do with the fact that the Crown didn't put to Dr. Hastings in the second trial in 2016, didn't challenge his evidence that it was 1 to 2 weeks. And if you look at, I don't have time to take your lordships to it, but I do respectfully invite your lordships to look at the cross-examination of Dr. Hastings in the second trial, and you'll see, I think it's fair to say that counsel was having a pretty bad day. He turns up late, he doesn't hear half of the evidence, he then puts a couple of questions that are irrelevant to Dr. Hastings, and then the judge then remonstrates him halfway through his closing submission, saying, well, hang on a second, you turned up late, we start here at 10:30, what's all this business? And then counsel doesn't put the key point to Dr. Hastings, which is, hang on a second, don't we mean 2 to 3 weeks? So, of course, the evidence before Isaacs, Jay, in 2016, again, was the expert evidence was that these injuries occurred within the time that the appellant was in custody. Well, obviously, he's going to throw out the confession evidence in those circumstances, because the unchallenged expert evidence was that. These aren't, these aren't unexplained inconsistent verdicts. And it's obvious why different results attained at these two hearings. Finally, on the point of inconsistent verdicts, there are 3 cases cited by my learned friend. I don't have time to go to them, but in my respectful submission, when one reads them, they really do fail in any material sense to elicit or explain what are the underlying principles governing the court's discretion with respect to inconsistent verdicts. They don't actually assist in explaining on what basis a court would overturn an apparently inconsistent verdict. What they do emphasise is it's a matter of looking at the facts, and it's not just a bright line rule. And in this case, of course, there are, it was said earlier on, I think, by my learned friend, well, the evidence was exactly the same in both trials, but it wasn't exactly the same because Dr. Hastings' evidence was different. But of course, and then the second final point is, these aren't inconsistent verdicts of juries. All you actually have is a verdict of a jury in one case, and then a decision on a preliminary evidential objection in a different case. Those aren't actually inconsistent verdicts in the sense articulated in the case law. I'm getting shakes from behind me, so thank you very much. Those are my submissions.
Are you able to assist us in relation to the nolle prosequi?
Not at the moment. Precisely what happened. Can I endeavour to find precisely what has happened and put in a short agreed note within?
Yes, please.
Sorry.
The board would want to know the basis on which a nolle prosequi was entered in those cases in which it was entered, and why it was not entered in the case of the outstanding charge in respect of murder.
Which is now 13 years ago.
Yes. Thank you very much.
Thank you, Mr. Pennington-Benton.
My Lord.
Bowen.
My Lords, can I just endeavour to answer some of the questions that were put to me during my submissions this morning? The first one was by my Lord Legate in relation to the questions or the exchange between Mr. Justice Isaacs and counsel in the 2016 trial. It's page 387 of the bundle. We have been trying to get to the bottom of this, and we have been unable to do so because it appears, as my Lord Legate observed this morning, that Mr. Justice Isaacs must have, if counsel was right, heard a case previously in which he had rejected the Crown's evidence of prosecution. Now, what is clear is that the nolle prosequis were signed by Mr. Justice Isaacs. Some of them were prior to August 2016, some of them post-dated. Without going into the ins and outs of it, we were going to suggest the very thing that my Lord has put to the respondent, that they, perhaps at the same time they put in their supplementary submissions, put in, not a note, an affidavit with a proper, to be properly attested to, explaining what happened in each of the nolle prosequis, and also to explain, if possible, what case is being referred to at page EB 387. And so, my Lords, we're not in a position to assist you any further, but it does appear that there looks like there was at least one other case where the same confession evidence, or confession evidence from the same period, was not accepted by Mr. Justice Isaacs. The second question I was asked is whether I made the submission that there was no evidence other than the confessions in relation to any of the matters to which Mr. Ariste had made admissions in July 2010. I was then pressed to substantiate that, and I demonstrated that that is the case in relation to certainly the 2010 armed robbery, the 2016 armed robbery, and the murder which is still outstanding, because that is the evidence of Miss Mason-Smith. I have asked the question of Miss Mason-Smith, was there any other evidence in any of the other cases? Her understanding is that there was none, but again, we would respectfully request that the board, through the board, that the respondent answer that question as well. Is there, in any of those cases, any independent evidence other than the confession?
So that's what you refer to as the 2010 robbery, the 2016 robbery?
Yes. But in relation to any of...
And which murder?
Well,
not Miller.
The pending trial, the pending charge.
And any of the other matters to which he pleaded, so he made admissions in 2010. Because my case is that this was, in essence, a complete fit-up in relation to all of the matters that the appellant made admissions to. He was beaten and tortured and forced to make admissions in cases where there was no evidence against him in any of these cases. And my lords ought to know whether that in fact is the case from the respondent. One might have expected them to have put evidence in already to that effect, if that is the case, and we would respectfully ask that the board put to the respondent that they answer that question as well. That is to say, was there any independent evidence in any of the other cases to which the appellant made admissions in 2010? So that is our request, if I can do that.
Right, we'll consider that in a moment.
I'm very grateful. And then I was asked what current police practice is in relation to the recording of interviews. And I've taken instructions on that, again, from Miss Mason-Smith. I understand that following 2 deaths in custody that happened in the criminal detective unit in 2013, practice was changed, and it is now expected that there be video recording of interviews, although I understand from Miss Mason-Smith that it doesn't happen in all cases. But again, it may be something, my lords, that you would wish to ask the respondents to clarify.
Would there be some standing order relating to that?
My lords, again, that would be helpful to us and certainly to the board to have an answer to that question, but it's not one that I can answer. So, my lords, just then dealing with the points made by my learned friend, he has repeated his complaint that grounds 1 and 2 were not raised before the trial judge or in the Court of Appeal. I think he puts the point rather faintly in relation to the trial judge, given that my client was unrepresented, but he says that there's no excuse or explanation offered as to why counsel in the Court of Appeal did not raise these points. 2 cases, my lords, I'll just give you the references. Benedetto, paragraph 65, page 762 of the electronic bundle, where Lord Hope made the point that an appellant, a defendant, is to be punished for the crimes he has committed, not for the failures of his representatives. And Baptiste, paragraph 6, page 734 of the electronic bundle, where 734, where neither at trial nor in the Court of Appeal had the point about the failure to provide legal advice or access to legal advice. That point had not been taken, but the board went on at paragraph 11 to find that that's something that the judge should have taken into account. So they considered the breach of constitutional rights appeal, notwithstanding it had not been raised either before the trial judge or the Court of Appeal. My lord, as far as ground 3 is concerned and the rule against appeals against concurrent findings of fact, that of course only applies to ground 3 insofar as it's based upon the ground that the statement should not have been admitted because it had been obtained by coercion. It doesn't address our arguments that it should have been excluded on the grounds that there had been a breach of the constitutional right to access to legal advice. And we have 6 reasons why their concurrent findings of fact rules should be overturned or should not be followed in this case. And just briefly, so this is on ground 3. Firstly, we don't know what standard or considerations the judge took into account because he's not given us any reasons. You'll find that in our written case by reference to the Wallace case. The same conclusion was drawn in the Tilmer case, that there should have been reasons. Can I just give my lords the references? That's a very recent decision of the Bahamas Court of Appeal, paragraphs 15, 27 and 29. Tilmer is spelled T-I-L-M-E, and you'll find that in volume 1, tab 5, starting at page 635. And the recent case of Glinton, G-L-I-N-T-O-N, paragraphs 32 to 36, that's supplementary bundle 67. And in those cases, there were no reasons given by the trial judge for his decision to allow evidence to be admitted, and in both cases the Court of Appeal overturned the conviction, among other reasons, because there'd been a lack of reasons.
Those were confession cases?
Those are confession cases. My lord, the second reason for rejecting or not following the rule against concurrent findings is that the Court of Appeal, although, yes, it did reject the appellant's appeal against conviction, it did so in a very short judgment, dismissing what it called the appellant's incredible story of beating. And since that judgment, which was in February 2013, the Bahamas Court of Appeal has accepted a number of incredible stories of beating. One is in the case of Tilmer, I've just given you the reference. The other is in Glinton, which I've just given you the reference to. And the other is a case called Rolle, R-O-L-L-E. That's at bundle, supplementary bundle, page 75. And my lord, in each of those cases, allegations were made that the police had beaten and placed a bag over the suspect's head, exactly the same allegation that was made by the appellant. It's called fish bagging. It even has a name, my lords. And in each of those cases, the Bahamas Court of Appeal has overturned those convictions. So it is no longer an incredible story of beating. The third reason to reject or not to follow the against concurrent finding is, of course, that Mr. Justice Isaacs has considered the same evidence, or has considered the same witnesses' evidence in the second trial in 2016 and reached the diametrically opposite conclusion to Mr. Justice Turner. And of course that wasn't known at the time of the 2012 trial. We do rely, my lords, on 3 cases which support the proposition that a subsequent acquittal, which is inconsistent with a prior conviction, cannot stand. They are, in our written case, they are the cases of Warner, Andrews and Ireland. I will only just take you to one of those.
Sorry, what's the point for which they're authority?
They are authority for the proposition that a subsequent acquittal on the same evidence means that the prior conviction can no longer stand. My lord, I'll give you the reference in our written case to those. It's page 537, and it's paragraph 72(3), and you've got the relevant passages there. I don't need to take you to those. The fourth reason for not following the rule against concurrent findings is that we now know that the Attorney General has entered nolle prosequis for the other offences as well. So we now face the situation that of what appears to be at least 8 admissions that were made in July 2010, all bar this one and the outstanding murder, have been discontinued either by the courts, finding that the matter cannot stand applying the rule against coercion, or because the Attorney General has entered a nolle prosequi, and my lords have already asked the Crown for further evidence about those circumstances. And my lord, fifth, you can depart from the usual rule because of the inherent improbability that during a period of detention the appellant voluntarily confessed to at least 8 offences or groups of offences, including, it appears, 2 counts of murder and 3 armed robberies, for which there was no independent evidence, and while refusing a lawyer. We respectfully submit that that defies belief. And my lords, lastly and sixth, the inherent improbability of the police's account of how the appellant received his injuries, namely that he had received them prior to his being detained, bearing in mind that there is no record in the detention record of any injuries at the time he's admitted, and there is a succession of entries following his admission saying suspect checked, appears well. So those are the reasons why ground 3 should be allowed. Just to come back to ground 1, to make a few points in response to my learned friend. He says that the right under Article 19.2 is fundamentally different to the right under Article 6, and for that reason he must be saying that it's fundamentally different to the right as it appears in the Trinidad and Tobago Constitution, Article 5. Now, we accept that there is a difference between Article 19.2 and Article 6 to this extent, that it doesn't itself codify a right to legal aid. However, it does codify these rights: the right to consult with a solicitor of his choice, including by telephone, the right to have his solicitor or his attorney present during his interview, and the right to be notified of his right. And it's our submission that those rights were all breached in this case. So we don't need to establish the fourth one, which is that there's a right in some circumstances where the interests of justice require for legal advice to be provided by way of by the state. Now, my lords, my submission is this: you don't have to decide that point. You do not have to decide that there is a right to legal aid for a defendant in police custody. We have not asked you to do that. If we were asking you to do that, we would have made it much clearer at an earlier stage. However, my lords may take the view that it follows as night follows day, that there necessarily must be some such cases, because necessarily there will be cases where the absence of legal advice at the time of detention will mean that there is an unfair trial in breach of Article 20. And if that is the case, Article 20 is not qualified in the way that Article 19.2 is. And by parity of reasoning with Hines, we say there must be some circumstances. It's not necessary for the court to say what they are, but just to identify that there are likely to be some such circumstances, and it's a matter that the Bahamian legislature needs to address. As far as the burden and standard of proof is concerned, we don't need to persuade you that we're right about the approach that's been taken by the European Court of Human Rights and the Supreme Court, because we get home on the basis of Mohammed. Lord Steyn in Mohammed, and it wasn't just Lord Steyn, it was a unanimous board, made it very clear that where there are any disputes of fact relevant to the question of whether there's a breach of a fundamental right, the burden is on the prosecution to establish those facts to the criminal standard. Now, the obvious, he said, he gave an example of one such fact, namely whether the police had deliberately withheld the right of access. But another obvious fact, which is likely to be in dispute, is whether notification of the right was given in the first place, whether there has been a valid waiver, that's to say one that's the one that's informed, voluntary, and unequivocal. And those are matters, therefore, that must be proved to the criminal standard. And I think it's it's my learned friend's position. He accepts that if this was the Crown Court, if this was the Supreme Court, if this was the trial court, that is the approach that would have to be applied.
What precisely was the point in Mohammed? It was.
So Mohammed was
wasn't notification.
Mohammed was it was whether a statement that's been obtained in breach of the fundamental right of access to a solicitor under Section 5 of the Trinidad Constitution necessarily means that the statement must be excluded at trial. And the court considered, firstly, a Miranda argument that automatically it should be excluded. Secondly, a prima facie argument that it should be prima facie as an exclusionary rule, and rejected that, but concluded that it's a matter for the court's discretion, but that any disputes of fact relevant to that question are for the Crown to establish to the criminal standard. So we say it is for the Crown to establish if there was a valid notification given, if there was a valid waiver, and if there were compelling reasons. But they don't say that there were, but they do say that there was that notification was given, and they do say that there was a valid waiver. Well, they must prove that. So we do not have to prove that he was denied the right of access to a solicitor. We do not have to prove that the statement that he made in his witness statement, which may or may not have been obtained under coercion for my lords to decide, but we do not have to prove that he was coerced into saying that. We do not have to establish that he asked for a lawyer and was told, no, you don't need one, and was then beaten. All that has to be satisfied, what must be satisfied is this: you must be satisfied, we say, to the criminal standard, that he was given notice of the fact he had a right to a lawyer, and that if he was...
But that's looking at it the wrong point of view, isn't it? Surely it was for the prosecution had to prove before the judge, as one aspect of the voluntariness of the statement, that he made a free choice not to have a lawyer. If the judge had given some reasons, we would have known whether he had engaged with that or not. But that was where it had to be proved.
Well, my lord, I agree with that. What I do say is this: that if the trial judge didn't decide that, and so my lords don't have the trial judge's reasons for...
Well, then he failed to decide something that was a precondition of admitting the evidence.
In which case, you do not need to decide the issue for yourselves. But in one of those cases where you did have to decide it for yourselves, then it's our case that you would necessarily, just like the Court of Appeal, would apply the same approach that the trial judge would have to apply, but only if you felt it necessary to decide the issue on the facts. But if you did have to decide it on the facts, the burden would be on the Crown to prove it to the criminal standard. But, my lords, I accept, and indeed it is our case, that the fact that the trial judge did not address this means that in and of itself there's been a failing, which means that the fundamental right has not been respected, and it's one that goes to the fairness of the trial to the extent that this court should find there's been a breach of the right to fair trial, and this court should in any event find that the witness statement should have been excluded on that basis. So, my lords, I probably don't need to get into the issue of burden and standard of proof in relation to Article 6, because Mohammed is so strong on this point. But just very quickly, our case is that we accept that the starting point in any claim of a breach of the Convention, and this must also follow for a breach of the Constitution, is that the applicant, the claimant, must establish that there is a breach. But the point about what is said in Simeonovi, and you were shown paragraph 124, the point about the approach that the Strasbourg Court says is that if sufficient evidence is shown, for example here, that an individual has not been provided with the right, or has not had legal advice at the time of their interview, that shifts the burden. It creates a presumption, a rebuttable presumption, that there's been a breach of the right of access. And it is then for the prosecuting authorities to rebut that presumption. And that is why when you read simi novi paragraphs 115, 117, 118, through to paragraphs 132, the Grand Court consistently says that the burden is on the prosecuting authorities to prove that there's been notification, that there's been a valid waiver, that there's been compelling reasons, and if those things have not been established, that the trial has not been unfair as a result. And my lords, that's what we have to say about that. Now, my lord, it is explicitly Mr. Pennington, my learned friend's submission that the fact that the trial court accepted the truth of Mr. Ariste's confession, which included his refusal of a lawyer, must mean that the judge and jury have in effect found that he made such a refusal. That is to say, when at page 170, he says, "Do you want a lawyer?" The police officer says, "Do you want a lawyer?" And he says, "Nah, y'all, I'm straight. Y'all got me, or y'all done me." That he was, that the judge and jury must have accepted that he used those words and that he meant them. It follows, he says, from the trial judge's findings and the jury's findings. And of course, that is not correct, because that was not the question that the trial judge engaged with. We certainly, or at least we don't know whether he engaged with it because we've got no reasons. He did not ask himself the question, was there a valid waiver of the right to legal advice? And the jury certainly didn't address that question. So it doesn't follow that they must necessarily have accepted that not only they rejected his evidence of coercion, but they also concluded that he must have validly waived his right to a lawyer. The two are separate and distinguishable factors. And what is clear from the case of Akdag and Bayar, and I took you to Akdag, I'll give you the references in Bayar as well, is that in every case where there is an issue as to whether the suspect had a right of access to a lawyer at the time of questioning, not only must there be consideration as to whether there's been coercion, if those allegations are made, but also there must be consideration given to whether there's been a breach of the right of access to a lawyer. So in Akdag, it's true that both allegations were made, but in Bayar, only the second one was made. So you'll see, my lords, paragraphs 131, 134, and 135 of Bayar, and that's page 1997 of the electronic bundle.
Sorry, 131,
134, and 135, starting at page 1997.
Thank you.
Now, my lord, there were some references to the evidence of Mr. Ranger, of DC Ranger on the voir dire, and my learned friend took you to his evidence and also Mr. Smith's evidence, where they said, in terms, he was advised of his rights to have an attorney, and he took you to page 71 and page 168, line 1. Now, my lords, you've seen the actual words that were recorded in the statement, and that is not what the statement says. The statement says, do you want to have a lawyer? It doesn't say, you've got a right to have a lawyer. And we say that that is a critical distinction, bearing in mind what you have to do here is be satisfied, or the judge would have had to be satisfied to the criminal standard that he made that he was notified of his right and that he made a valid waiver. That is not.
It's 171 and.
So the references to Mr. Ranger's evidence were 71 and 168, where Mr. Ranger's evidence, DC Ranger's evidence, was that he was advised of his right to have an attorney. But contrast that with page 170, where you have the actual words, and the actual words are, do you want to have a lawyer? Which is not the same as saying you have a right to a lawyer. And I've shown you the passage, I've shown you the pro forma wording on the detention record, which should have been completed if Mr. Ariste had been notified of his rights to a lawyer, and they are not completed. page 8 of the bundle, that pro forma on the detention record. Then Mr. my learned friend said this. He said, should the judge himself have raised the issue of waiver, which is essentially our case in circumstances where, like this, the defendant is unrepresented and hasn't raised the issue himself? He says that there couldn't have been an investigation by the trial court because that would have been a recipe for disaster. He says that the judge can't clarify factual disputes which are relevant to the question of whether there's been a breach of the right under Article 19. Well, that's patently absurd because, of course, the judge does have a duty to determine issues that are relevant to whether there is a breach of such a fundamental right. See Mohammed, where Lord Steyn, giving the judgment on behalf of the whole board, said one example is that the right has been deliberately withheld. Now, how is a judge going to determine whether the right has been deliberately withheld if he's not asked the right questions? And of course, he has to ask the right questions if the defendant isn't asking the questions himself. So, my lord, it is an absurd proposition to say that a judge cannot ask those questions in circumstances where the individual is unrepresented. My lords, last point, ground 2, you do have some evidence of what was said on the 2nd of March and what was said on the 5th of March in terms of the inquiries that were made by the judge as to whether Mr. Ariste had given a voluntary, informed and unequivocal waiver of his right to legal representation at trial. The first one is page 57 of the supplementary bundle, and I'll just show it to you, which is the
Really out of time now.
the contemporaneous record.
Really out of time now.
My lord, I'll just give you the reference, page 57.
Well, what does this say?
It is the reference that shows what was said in court on those days. And it's the best evidence that you have. So page 57 of the supplementary bundle and page 41 of the electronic bundle. We respectfully submit that that is not enough for you to be satisfied that there was a voluntary, informed and unequivocal waiver, and in any event it's perfectly obvious that the trial judge did not carry out a Bain inquiry. And my lords, I don't need to take you to Bain. You have all the references. My lords, unless I can be of any further assistance, those are the submissions on behalf of the appellant.
Thank you. Mr. Pennington-Benton, do you want to say anything about the shopping list that Mr. Bowen has published?
Any instructions yet, obviously, on what can be achieved, but I think we're certainly happy to agree with, sit down and agree with my learned friend to get as much of that information as we reasonably can.
Thank you.
I don't see why certainly the information about why the, whether there was any additional evidence and stuff like that, I'm sure that's quite straightforward.
Whether there was another hearing ought to be possible of determination, whether there whether the council was just wrong in suggesting there'd been a previous hearing, or whether there had been. That could surely be checked.
That's also okay. I'll add that.
Either there was or there wasn't.
Yes.
There must be a record of that somewhere.
I don't think I remember any of the requests sounding impossible. So we want to sit down with work it out.
Yeah, on affidavit. This is important. Right, Mr. Pennington-Benton, well, I'm grateful. The items on the shopping list include whether there was another hearing, referred to by Mr. Justice Isaacs, whether there was any other evidence other than confessions in relation to any of the 8 offences alleged against Mr. Ariste, current police practice in the Bahamas. And you're also going to provide the information we've asked for in relation to the nolle prosequis. So there are 4 items in total.
the police practice one? I'm sorry.
In relation to the current police practice in the Bahamas,
Recording,
recording interviews.
Four bits of homework.
And we'd be grateful for those on affidavit, please.
My Lord, in relation to the...
We ask for an affidavit because this is important.
Yeah.
In relation to the nolle prosequens, I think, my Lords, were asking for the reasons why the nolle prosequens were entered and why one was not entered on the murder.
Indeed. That's ground that's been covered. I think that's understood.
Yes.
My Lord, Mr. Pennington-Benton did ask for, I think, my Lord's suggestion, I'm not sure, some time to put in a supplementary written response. I'm not sure whether he's still maintaining that or whether my Lords are...
Yes, we'd be grateful, Mr. Pennington-Benton, if you want to put anything in further within 14 days.
Great.
My Lord, may I? I'm not promising that I'm going to do anything of the sort, but if there's anything that's new in there,
I'll behave myself.
I don't need a direction from my Lords. I will exercise it responsibly, but if there is anything new in there...
You don't need direction, you need permission.
Permission, my Lord.
And we'll give you permission to put in anything which is in reply, and it must strictly be in reply within 7 days thereafter.
Well, I'm very grateful, my Lord.
We're very grateful to all counsel for their submissions in this important matter. We're also very grateful to those sitting alongside you and behind you for the preparation of the case. The board will take time to consider the advice which it will humbly tender to His Majesty. Thank you very much.